to ask the members of the panel to come immediately here from the desk. Elena Munoz, Ruja, Daniela Spiro, Jean-Pierre, Marielle, Jean. Great stuff. Okay. So this is the European border team representing yeah, a total of 7 countries. 7 countries. That goes, of course, along with the 7 principles established in the EFC judgment of the Strasbourg Court. You remember information, interpretation, legal counsel, and effective remedy, inquiry about the consequences of removal, and the training of border guards. So these are the 7 points on which we have together investigated what is the reality on the ground. I would like to beg your excuse that it is not the intention now that we present the situation in 7 countries, because we may know that for the public a little bit boring, but try to point on very specific questions, and we have been several times on the floor. My first question would be, we are speaking about borders, we are speaking about access to protection, we are speaking about the mechanism to prevent the risk of refoulement, based on what is said by the Strasbourg Court. Taking this into account and taking into account the research you have conducted in the various countries, could you highlight 2 major concerns you have? And if there is any, 1 good practice. 2 major concerns and 1 good practice. I know you may have 15 concerns, but try to select those that you deem to be in particular worrying, and where maybe such intervention, as suggested also here, like infringement procedures or interventions from the European level, could be eventually envisaged. Should we start with the Brazil, Marie-Pelzer, Germany? You know that Germany had an important part in the project with regard to airport arrival at air border, and the experiences made there. So 2 major concerns, and if there is any, 1 good practice. Marie.
Okay, thank you very much. Yeah, we were looking at the airport procedure in Germany. I give just short explanation how this works so you can understand our major concerns. So the airport is actually our external border. We don't have external land borders. So we look at the airports. If we
Sorry, if you have external sea borders like the port of Hamburg and Bremen, how many asylum seekers are arriving there?
Not so many. Sometimes actually there are also minors in some ships, but it's very, very seldom. If it appears, it's also very problematic. But in this study, we focus on the airports. We have in 5 airports the airport procedure, asylum procedure. Mainly in Frankfurt, but also in Munich, Berlin, Hamburg, and Düsseldorf. This procedure is an accelerated procedure for certain groups. Not all, but everybody who arrives at the airport is going through this procedure, but only if you are coming from a non-Schengen country without false papers or documents, or if you are coming from a safe country of origin, which is for Germany, Senegal and Ghana, and in future also the West Balkan countries. But they are actually not coming through by plane, they are coming by the land borders. So this is what is a ground for our concerns and many problems. It's a simulated procedure. The whole procedure takes place in 19 days until the court decision. So you don't have really any time for good information, preparing for the interview and so on, and even to find a lawyer and give legal advice. And so it's very, very difficult. For example, in Frankfurt, the churches provide social and support and advice for the asylum seekers, and they are trying to find out the most vulnerable groups and get them into contact with lawyers so that they at least have legal representation. The asylum procedure takes place in closed buildings, so it's like detention. Now I come to the role of the border police. So they are actually the first one who getting in contact with the asylum seekers or migrants. So they are the ones who have the task to find out if there is a person who is going to apply for asylum or if it's just a migrant. If a migrant tries to enter Germany without papers, or even if they don't believe the reason why the reason for applying for visa or coming to Germany, and they doubt that they are going to reject the person and send them back home. But of course, if you are an asylum seeker, they are obliged to pass the case over to the Federal Office for Migration and Refugees in Germany, and they are doing then afterwards the asylum procedure within the airport. So this situation with the border police is very important and also very difficult, because at this point it's decided if people are actually recognized as asylum seekers or not. So we had in the past cases where border police said, well, the person didn't say the word asylum application, so we don't see any asylum application, or the person didn't come from a country where the border police suppose that this person can be a refugee. So there was a case of 3 little Chinese minors that arrived some years ago at the Frankfurt airport, and they didn't get any legal advice or representation by a lawyer or someone else, and they were sent back to China without any procedure or anything. So this is a big concern what happens during the procedure with the border police. We don't have any legal standards for it, no guarantees for legal aid or information, or even translation. Of course, the border police is using interpreters because they want to find out something from the persons, but there are actually no guarantees for the migrants or asylum seekers. After the person gets to the asylum officers and is getting the asylum procedure within the airport, they are sent to such a detention building. You can see play stuff for children, so you can understand that also children and minors, unaccompanied minors, are, if they are 16 or 17, are detained in such centers. Yeah, so this is also a problem that vulnerable groups are also in these airport procedures. And but I have to say that the numbers, the figures are not so high concerning, or if you see the applications in Germany as a total. Last year we had more than 100 asylum applications, and we had 972 asylum airport procedures. So not so many, but and not so many negative decisions, like 48, and the rest more or less was able to enter Germany and go.
One question. A little bit linked also when we look into the Dublin statistics. From an efficiency point of view, is it worse, the whole thing of the airport procedure, when at the end of the day you have such a small minimum number of persons rejected, not admitted to the territory, into the normal procedure? So isn't this an argument to say, let's overcome this? It makes no sense, because you have all this apparatus and detention and so on and so forth, and then at the end of the day, you have 48 asylum seekers less out of 130,000 last year, and this year probably 200,000.
Yeah, I mean, we argued like that, and but our conservative politicians, they see this as an important measure. They really fought for it also on the European level when the Asylum Procedure Directive was negotiated. So for them, it's like a symbolic value because it's part of the deterrence program of Germany. You know, you must see it like that. From a practical point of view, the numbers are low, and but from our point of view, for Asyl, you have to look at the single case, because here the risk for refoulement to the home countries is really high. Some years ago we had 3 refoulement cases to Eritrea, because the procedure in the airport is so fast and so bad, and the staff of our authorities is really bad in this Frankfurt airport. So they decided, they rejected those Eritrean asylum seekers, and they were sent back to Eritrea and were tortured there. So this was a really tough case. Yeah, but we can't see right now that the politicians stick to this system. Yeah, and yeah, Asyl did for a long time, many years, criticize this airport procedure because we are located in Frankfurt, so we have close contact to the people there. And so, but what is really hard to find out anything about is what the border police is doing. So it's not transparent at all. We can find more out when the asylum procedure actually starts. But which persons were rejected by the border police, it's really hard to find out, and there's really a big lack of information, legal support, and the asylum seekers are often also very frightened. The first contact is police at the airport. So what we are recommending is some sort of independent advice for asylum seekers already in this situation, meeting the border police, and it has to be independent, but on the other side, we may need finance for it. Yeah, the state has to finance, from our point of view, such legal advice to be in line with the HIRSI decision and also the European law. So thank you very much.
Is there any good practice you could mention?
No, I don't know, the airport procedure is not acceptable, and so we are campaigning against it. We want to abolish it. So this is no good practice. Maybe what the NGOs are doing and the churches giving help to these asylum seekers is a good practice, but the status is not useful at all.
Thank you very much. Elena Muñoz Martínez, CAH, la Comisión Española de Ayuda a Refugiados. Always under this aspect, yeah, what are, you can say, okay, we have two major concerns. One is social life, the other one is media. So what is in this period, yeah, or the last month, so your major concern, that maybe there is any effect?
Okay, yes. Our main concern these days, Ceuta and Melilla, Sahul. We have denounced the situation since 2005 because the legal devolution has happened since then, or even earlier. But it's true that this year, 2014, have been on the media focus. So we have a lot of videos and photographs that can be used as evidence of this illegal devolution that is happening at our borders, at our land borders. Our main concern is that in this illegal devolution, that where there is not any administrative procedure, it's not guaranteed any legal assistance, internet service, information to the migrants. They are removal without any procedure and without any procedure guarantee. This is a very big difficulty to the access to the protection. And we see that in the situation in Ceuta and Melilla for the asylum seekers who are able to get into the territory and effectively do the asylum petition at these two cities. It's also very difficult for them because they have very limited their freedom of movement. They are not allowed to move to the peninsula. Also, in the last month, we have the government has authorized some transfer of the asylum seekers, most of them Syrians. Also, we have seen this in the last months some asylum petition at the border point, at the official border point of Ceuta and Melilla. And we have had, I think, 16 up to now, and they have been transferred to the peninsula also. So this is one of the new things that we have during this last month. Another concern that we have about the whole border control and access to protection is the identification of vulnerable migrants. According to the law, we have some procedure for the victims of trafficking of human beings and also for unaccompanied minors. It's very guaranteed, this identification process in the law, but in the practice it's very difficult to carry on this identification due to the time limit in the border procedure. We have also an asylum border procedure that is in 72 hours. So in this time, we have to identify if this person is or not is a victim of trafficking of human beings, and do all the procedure to decide if the government accepts them to get into Spanish territory and continue with the procedure. So it's very difficult to identify these vulnerable profiles. And also, apart from the time limit, is the situation of these persons that are detained at the airport. And sometimes they are detained with the same smugglers or traffickers, and it's very difficult that one person can explain the full situation in a room where the smuggler is in the other room. So we have so many problems in this kind of identification process. For me, it's very difficult to find a good practice, but we have good news for the court. The European Court of Human Rights has decided that Spain has breached the Article 13, the sexual to affective remedy, because our asylum procedure doesn't settle a suspensive effect to the appeal of the decision of the negative asylum decision. So on April, the European Court of Human Rights has decided that Spain has breached this article, and we hope that we have some change in our law regarding this aspect. Another good practice is for another court. This one is two Spanish court, the Barcelona and Madrid court, of surveillance of the detention center of immigrants, that have decided that in the papers or in the information papers, that all the migrants who are getting to a detention center have to be handled. They are going to introduce a paragraph about the international protection asylum procedure, who was not before. So we hope also that this can help to the access to protection for the migrants who are detained in the detention centers.
Thank you very much. On some aspects we will be brought, in particular on the question of effective remedy with regard also to detention. Daniela Delgado, Chief.
Yeah, good morning. Okay, good afternoon. So just to a little bit explain about in a minute about the good practice that in Italy we have. That is to say, our immigration law provides the possibility, the right for, not the right for NGOs, but the possibility for NGOs to stay at border points, official border points. This is possible under an agreement with the local prefectures, and under this agreement, NGOs could, in theory, have the possibility to approach in autonomous, independently way, migrants and asylum seekers, because the law provides the possibility to provide information to asylum seekers, but is addressed to potential asylum seekers. That is to say that NGOs can have possibility to approach and to inform migrants. In practice, this is possible only if the NGO is authorized by the police, and it is true, for example, in the Adriatic Sea, when we have the possibility to inform migrants or potential asylum seekers, in the case we obtain an authorization directly from the police or even from the captain of the vessel coming from Greece in this case, to provide information to people who would like to ask or not in Italy, before eventually to remove to Greece or ask for asylum in Italy. So in practice, what I would like to say is that the main concern is probably the possibility to provide legal assistance to migrant or potential asylum seekers before this person can be subjected to a removal order. Penso che non c'è abbastanza tempo. Then, if there are questions, we can clarify.
Perfect. Thank you. Spiros, Greek Council for Refugees. Can you start with good practice, please?
I leave it for the end. Very good practice. So about the airport, the information is, we have no information, unfortunately, about the airport, what's going on, especially at the transit area. The point is that according to my information, there is no data on the asylum procedure at the airport, and if there are some asylum demands at the airport. So I have no idea of what's going on. There is a case, this happened in August after the report was written, about a Turkish Kurdish origin person extradited by Cyprus back to Turkey and passed from the transit zone of Athens airport. So we had the information by an NGO, Kisa from Cyprus, a Greek Council for Refugees. Immediately when we had this information, we phoned the airport, but the police of the airport did not said to us that they could not intervene because the plane was ready to fly, and the Aegean Airlines denied to stop the airplane because the information we had is that this person sought asylum in the transit zone. So this is the only information I have. And because of that, it is quite difficult to have the possibility to go to the airport or to discuss about the possibility to have access to the whole procedure, because it seems that the major problems are in the land borders and the sea borders. So beginning from sea borders, I have to mention what we read in our report. It is written in English, thinking that it would be, I mean, it will be read more in abroad than in Greece. So the coast police informed us that there is a very close cooperation of the Coast Guard of Greece with the Turkish Coast Guard, which is a very good news. Maybe it's a good practice of the cooperation of the two countries. What happens? Sometimes the Greek coast guards enter the Sea of Turkey. They stop the boats and they stop them. They collect the persons and then they inform the Turkish guards to take these people back to Turkey. We have to say also that among them there were many Syrian people, and of course there are Turkish citizens. Unfortunately, we have no possibility. I mean, until now we don't have a person, so we can make something in front of the European Court of Human Rights. And of course, we have very tragic incidents, accidents. It is the language of the Greek coast police, in pharmaconis and so on, very tragic incidents. The scandalous issue is that in pharmaconis, where many people, there are evidences that there was a pushback to Turkey. The prosecutor of the naval courts are special courts, and there is a big discussion if these courts are constitutionally correct courts or not. So the prosecutor, even the information is tremendous, I mean, the findings, puts the file in the archive, and unfortunately there is not a remedy against this decision of the prosecutor of the naval courts. So these cases will be under the European Court of Human Rights. It seems that after the tragic incident that happened in
who brought it to the attention of the Strasbourg Court?
Lawyers, I mean, the members of the Greek Council for Refugees lawyers.
To your organization?
Yes, I don't know at which stage we are, but of course there is the only remedy. Yes, and after this tragic, it seems that the situation is getting a little better. I mean, we don't have information about such incidents. In incidents of pushbacks, is this what I mean? So what happens at the lab borders, the pushbacks is an everyday routine. Actually, me and my colleagues, we take phone calls from Syrian people in the Greek territory because through the technology, they know exactly where they are. What is really tragic, is the tragic irony, is that we inform them that if they call the 112, it is quite possible that they will be pushed back to the Turkish side. And these people usually tell us that we prefer to have water in order not to die and to get pushed back than not to give information to the police. Imagine us to inform them that even if they call the police, they will be get pushed back. And we know that many of them were pushed back because we take the information, we inform the police by fax, and after some days we have the phone calls of the same persons. So we have informed the police that the same persons who were pushed back came one more time, and we informed the police that these people were pushed back. I mean, we have, for example, the story of people who were pushed at the Evros river, and then they were pushed by violence to the Turkish side, and one baby was thrown in the water and had fever and so on. So it is written down, and ombudsmen know, Greek ombudsmen know about these stories. What happened when these people come to Greece? Unfortunately, I mean, there is a screening procedure, which is not well implemented. There's just one screening center. Unfortunately, Greek Council for Refugees and other NGOs do not have access to these screening centers to see what's going on, if these people have information or not. Only NGOs who collaborate with the Greek authorities, I mean, okay, we also collaborate with the Greek authorities, but they take orders from, they are like civil servants, can have access, of course, because they work in this center. So, unfortunately, there is an unofficial period of time where these people are, so the people who are not pushed back, okay, and they have access to get detained, because we speak about the access to get detained. They get detained for a period of time because the number of people who is in the screening center, the first reception center, is quite limited. They stay without no status, no prosecutor informed, nothing at all, and then they are put in this first reception center. They stay about 25 days, and usually they are put back to detention. In Greece, you know that there is for Greece there is a pre-infringement procedure against the indefinite detention of people who do not seek asylum. So coming back to effective remedy, I mean, the European Court of Human Rights said that there is no effective remedy for the people who are detained. And the good practices is that, except of very small threats lawyers have about the reporting what's going on and speaking, we are still free to tell you what's going on in Greece. Thank you.
Yes, please.
Just one clarifying question. You say there's an infringement procedure against the indefinite.
Free infringement. I mean,
Yeah. You say regarding migrants who did not ask for asylum. But isn't it so that you, even if you ask for asylum, you can...
Yes, the maximum period is 18 months from all cases. So, according to a decision, it's quite complicated. I can give you information, I'll give you the report on this. People who fail to get recognized as refugees and do not cooperate for their return to their country, they can stay indefinitely in detention. And this detention is called alternative measure. But the alternative measure is to stay in the same detention center where they were detained. So it is improbable, but it's not, it's a breach of EU law.
Okay, thank you very much, Spiros Jean-Pierre Cauchy, People for Change Foundation, Malta.
So one thing to start with, something to keep in mind about Malta is Malta does not intercept vessels coming towards Malta, except when they actually enter the territorial waters. But Malta has a massive search and rescue region, and therefore a lot of the issues that do arise out of vessels that are being officially rescued and rather than being intercepted by the Maltese armed forces. Search and rescue, as well as immigration on the water, is carried out by the AFM, the Armed Forces of Malta. Now, in terms of pushbacks, Malta has had a number of instances which were deemed to be the equivalent of pushbacks or refoulement. 2004, Malta sent a number of people back to Eritrea. In 2010, there was an incident where a vessel was in distress, and the Maltese Armed Forces rescued half of the people on that vessel. The other half were put on a Libyan vessel and taken back to Libya. There was no information available about how the decision was made as to who of this group of people that was on this one boat would go to Europe and who would go back to Libya. And we tried to ask questions about that as part of this project, but we couldn't really get any answers. Now, in 2013, Malta had the first case of attempted pushback. What's interesting to keep in mind is that the people were rescued, brought to Malta, and there was then the intention to take them on a plane from Malta back to Libya. Now, that was stopped by an interim measure of the European Court, but it was the first time that there was this direct kind of link to a pushback in Malta. There hasn't been another attempt since, except for within a few weeks of this incident happening, there was a private vessel that was instructed by the Italian SAR Coordination Center to rescue a vessel, and then both the Italian SAR Coordination Office and the Maltese one asked this private vessel, the MV Salamis, to take the migrants back to Libya. Now, the captain of that vessel refused, and he basically kept on going towards Malta. He was stopped outside the Maltese contiguous zone. The vessel remained there for a while, and then Italy took the migrants after about 2 days. So that was another kind of pushback attempt, and with the added interest of it being a private vessel, not a military vessel directly, although the instructions were being given by the SAR Coordination Center, which is part of the armed forces. So those are kind of the experiences of pushbacks in Malta. The other concern that we have is regarding the airport, basically, which is obviously we don't have a land border, so the airport, and the problem there is that there's absolutely no information as to what happens at the airport. When we did ask about this, what we were told is if the immigration official thinks that this person might be entitled for asylum, and the way they explain this is if he basically comes from a country where we know that there's war or persecution, then we basically inform the Office of the Refugee Commission, and then he gets into the normal asylum process. So Malta doesn't have accelerated procedures, it's all the one asylum process. In terms of good practice, I think it's about the next stage where, in terms of information about the asylum process, where compared to 3 or 4 years ago, you now have a significant effort by the Office of the Refugee Commissioner, which is the Status Determination Authority, to actually inform individuals who are detained. Malta does have a policy of automatic detention as soon as you have seen that, of the right to seek protection, what that actually means, what the process of seeking protection is. And that is done in different languages through the use of mediators, etc. So that is, I would say, a good practice.
Thank you very much, Jean-Pierre. Now we come to Ruja Matevčić of the Hungarian Helsinki Committee. They had Helsinki committee a little bit special status in the project because we made some activities and others not, but Hungary is very famous for its border monitoring experience. So is this a good practice, the border monitoring experience you have done, or are you still doing this?
Yes, we've been involved in this for 7 years now. And so when a migrant is apprehended at the border, he's explained his rights and obligations by the police. However, the right to asylum is not included in this. But what we have witnessed that recently police is quite willing to accept that somebody is an asylum seeker. So this, I would say, it's a good practice. However, we still have records of cases when somebody doesn't explicitly mention that he wants asylum. However, he's from Syria or Afghanistan and says that he left his country because of war or because his family members were killed and so on. And they would not be considered as asylum seekers, so they would be issued an expulsion order. The problem, okay, you can't force somebody to ask for asylum. However, even if you do return somebody, you still have to apply the principle of non-refoulement. And that's where we see a main problem, that the assessment of principle of non-refoulement is not done thoroughly. The reasoning is not really there. And plus, we are talking about Serbia, because majority of migrants come through Serbia, so they would not be readmitted to their countries of origin, but to Serbia. And my organization has issued 2 reports already on the situation in Serbia. We believe that it is not safe for migrants, either if they ask for asylum or if they do not. There is a risk of chain refoulement to Macedonia, to Greece, to Turkey, and so on. So this is problematic. Then, it's not so connected to this, but I can't go without that of course Hungary detains asylum seekers or non-asylum seekers, and this is also detrimental effect because many people, they prefer to withdraw their asylum claim once they are detained because they just can't stand the conditions or the fact that they are not free anymore.
Sorry, just understand. I'm an asylum seeker. I can be detained. Then I withdraw, and then what happens?
Well, if you were in Serbia before and Serbia does recognize that you were there, you were immediately returned to Serbia. If you are not, you are let free, basically, and you can go wherever you want. But people know about Dublin. They know that if they would leave, they would be sent back. And what is problematic is once you withdraw your application and then you actually see that you can't go anywhere and you apply again, you have no right to reception conditions. So then you are homeless. And now it's very time problematic. Winter is coming. It's a big problem.
Thank you so much. Jean Corte-Real.
If I could just
From the Portuguese Refugee Council.
yes, Portuguese Refugee Council, just give some context in terms of the nature and the scale of arrivals. Portugal remains as one of the EU countries with the smaller number of asylum seekers per population in Europe. And arrivals of third country nationals.
According to the plan of the Federal Minister of Interior, you will get some 20,000 according to your.
That's what we're looking for. We'll start doing something seriously relevant if we have the numbers. But arrivals of third country nationals take place over 80% at national airports and mostly in Lisbon airports. So our focus has been on procedures at the Lisbon airports, and also, despite the fact that we have very small numbers, there are still procedures being put in place by the Portuguese immigration service to prevent arrivals at the air borders from what are the most relevant countries of transit, notably, for example, in Guinea-Bissau. So in terms of the problems that we see, the most relevant and most worrying from both a legal and a practical point of view have been, in fact, this
policy that has been in place for a number of years of having immigration officers being posted at the airport in Bissau, where under an agreement with the national air transport company, they have been offering training to persons working for the company. They have themselves been present at the airport in Bissau and doing documental checks in a very informal way with the implicit agreements of the authorities in Bissau, and thus preventing potential asylum seekers of embarking. And we know that many of the asylum seekers who arrive in Portugal and manage to register their claim come through Bissau. So this is an issue for us. This has been, and I was listening to the words of Judge Albuquerque, and this was a big issue, and you might remember that flights from TAP have been suspended in August, because in August, a group of Syrian refugees forced themselves into the plane. And at the time, we got a lot of information additional information on what was going on in Bissau, because when we did the interviews with the immigration officers, they told us that basically, if someone was to express his wish to apply for asylum on the stairway to the plane, that they would refuse his boarding, and that he would just be accepted into the territory, would just be identified prior to arriving. Well, of course, this is not necessarily the case. The reports from groups of Syrians being denied boarding in Bissau have since been made public by the media, and meanwhile, in this summer, the Portuguese government has now entered into a cooperation protocol with the Bissau, with the Guinean authorities, in order to implement training and pre-boarding controls at the airports. This has been suspended for the time being due to the Ebola. Those flights have not yet been resumed, but we don't have much more information than that. But this is, of course, a worrying practice. Now, in terms of those asylum seekers arriving at the border, notably in Lisbon airports, the Portuguese Refugee Council is present at the airport on a regular basis at the detention center to provide legal assistance, information and assistance to asylum seekers, but we do not have access to the transit areas. We do not know what happens to those who arrive at the airport and do not manage to register an asylum application. Sometimes we get calls from families or others telling us that there is someone at the airport who wishes to apply for asylum, for whom no asylum request has been registered, but on the part of the immigration services, we're told that they systematically refer migrants to the asylum procedure without the need for a tacit request for verbal requests for asylum. It's true that some of the asylum seekers have confirmed this, the ones we interviewed, but our main concern is that from the moment they arrive at the airport to the moment where they are notified of the rejection order, they receive no information whatsoever, both on asylum or on how to access asylum or any other procedure, be it special procedures for protecting trafficking, victims of trafficking or others. And this is particularly a particular concern to us, because this is compounded by the fact that there are problems in accessing free legal aid. Basically, the law provides for free legal aid to migrants. I'm not talking about asylum seekers, to migrants at the airports on the basis of an agreement between the Ministry of Interior and the Lawyers Association, whereby lawyers should be on call for those migrants who wish to appeal, to challenge their refusal order that will imply the return to their country of origin as soon as possible. But this simply isn't working. So this means that only those who have the means and also someone who is able to make those contacts and contact a lawyer on their behalf will be able to challenge that decision. And they have, of course, confirmed the immigration services that some were unable to access and some were sent back without having the possibility to challenge that refusal order that implied their return. Within this procedure, this refusal procedure, there is no assessment of any reform concerns. According to the law, it's even for the migrants alone to argue and to present the proof that he is facing a risk of refoulement when sent back, and this is of course problematic. So this is the two main problems. If I may just say a good practice, the fact that we do not detain in any manner minors in Portugal upon arrival at border points. So this is a positive.
Thank you. Thank you also for mentioning a case, an example of, let's say, outcasting border control for the Bissau. I think we have other cases, certainly also in the other countries, but we cannot do everything, but it's very interesting. This mechanism that will pre-advance the control, even in airports in third countries, in this case, an important country of transit, sometimes maybe also of origin. Please, if you have a quick, specific question to any participant in the panel, you have the floor.
Thank you, Professor. My name is Dimitris Palios, and I'm posted in a great permanent presentation. First of all, I would like to thank you for this quite interesting conference. And I would like to address some concerns regarding the statement of Mr. Koulekeris. If I was not a Greek, I would have the impression that in Greece we have a dictatorship. The way Mr. Koulekeris presented that the only, let's say, achievement is that he can freely express himself. But I think this is not the case, Mr. Koulekeris. You know very well that the last 2 years Greece has made a great effort to reform its asylum system. So a couple of years now we have a new asylum service, a new first reception service, a new appeal authority, and you know very well that we have increased our recognition rate regarding the asylum and international protection. Also, you know that these new services are in good cooperation with the UNHCR and a number of NGOs like Netadresi, and also with Bar Association regarding legal aid to the person in need. So I think we have to be, let's say, more objective regarding when presenting the situation in the member states. You know also very well that the last, let's say, 10 years, Greece have intercepted more than 1 million illegal migrants. We are in the front line, we are confronting with huge migratory pressures, and especially under the big economical crisis, big unemployment. We try to do our best to face this huge issue. So I think we have to present the situation as it is. Thank you very much.
Thank you. Please, very shortly.
Very shortly. I agree that the provision has ameliorated. I agree that the decisions are well substantiated. But the question of Mr. Hein, Dr. Hein, was not this general situation, is the access to protection at the borders. So the answers I gave had to do at the borders. According to there are breaches of law at the asylum service, and 2 cases before the Council of the State, Conseil d'État, the Greek Council of State, and big hearings. But of course there are positive steps to the asylum procedure, but not at the borders. This is what I said before, and I think that there was a misunderstanding. I'm really sorry.
Okay. I think it is very widely recognized also by UNHCR that after having been also condemned by the Luxembourg Court, by the Strasbourg Court, and and so on, there has been big efforts in general in Greece to improve the asylum procedure, the reception conditions, and so on. But we still, and we have here the representative of Brazil, very active and observing and monitoring the situation at the Evros River, at the Eastern Islands towards Turkey. We have a number of very serious incidents still this year with regard precisely to access to the territory, access to protection, incidents of pushing back to Turkey. It would be a different discussion that we cannot do it here now if pushback to Turkey amounts to refoulement in the sense of Article 33 of the Geneva Refugee Convention or not. One can discuss it certainly. But this is not here. It is a fact that pushbacks have taken place, and I think in general it comes out here that we have a problem of monitoring. We have a problem of really collecting precise information, and where we have access to information, then there are possibilities of corrective measures by court, national courts. You mentioned also court decisions in Spain, not only as a last resort, of course, Strasbourg, but also national courts. But you need information, and very often, also from our experience in Italy, very often, you have two contradictory declarations. The person who says, "No, I requested asylum," and the police says, "No, there's nothing, it's not recorded. Any protection request has been forwarded." So the monitoring problem is there. And problem, it was said also by the representative of the European Commission, sometimes there are not sufficient concrete elements really to start a pre-infringement procedure with respect of incidents of refoulement. If you allow, and if you do not have any very
Can I say,
yes,
just
please.
we have hundreds of interviews with victims of pushbacks, so we have a lot of evidence. So for Greece and Bulgaria too, different organizations went there, like Amnesty International, like Human Rights Watch, and so on. So we have a lot of proof. So I cannot understand why the Commission has such a problem to start an infringement procedure.
No, this is very important, but we had, on the other hand, we have here and there a monitoring problem, that it is not sufficiently institutionalized, or it is not sufficiently independent, or as we have it in Italy, you have the services at border points, where totally underfinanced, so that you can have a presence there 3 hours a day, but you don't know what happens at the rest of the day or the rest of the night. It's insufficient. Even there where some service is in place. I think it's not too much to say that when we compare the words of the judgment here against Italy with the reality as we have seen in these countries, we have a huge gap. We have still a huge gap. We have certainly here and there progress. This must be recognized. We have certainly no longer in Italy a pushback towards Libya. We have had some incidents of pushing back people to Egypt, not over the last months, as far as we know. But as a general policy of intercepting and pushing back people from the high sea towards an intermediate country or country of origin is no longer the policy. And this is certainly, among others, political factors, also a result of the judgment. we have certainly improvement in a number of aspects in Greece. I would say also in Malta, if you agree, yeah, in some aspects we haven't progressed. So it's not so that nothing is moving, and I think one could say really also that not to push back, but to push from the civil society organizations, sometimes together with allies in the national and in the European Parliament, have contributed, together with jurisprudence, have contributed to certain improvements. Nevertheless, and you see it also in the results of the publication that has been distributed here, when it comes to the second point, providing the right to information, the right to interpretation, legal counseling, effective remedy, the need to inquire about the individual consequences of the removal from the territory, and last but not least, training of border officials. When we have this checklist, yeah, these 7 elements that all are mentioned in the hearsay judgment, then we see in all the countries we have been investigating upon, or the 7 countries, there are more or less serious shortcomings and gaps. This does not mean that, to my mind at least, that the hearsay judgment has no effect, or that the principles have no effect. They have an effect because now we have also a stronger instrument. We, I say, lawyers and civil society organizations, we have stronger legal also instruments to say, okay, this is not in conformity of the European Human Rights Convention, it's not in conformity of the jurisprudence of the Strasbourg Court, and sometimes it is not in accordance with the common European asylum system, and it has been revised last year. May I say the question of access to protection, which is overarching theme of this conference here today, has so many different aspects. We have not been able really to look in more detail to the question of externalization of border control, outcasting, the role of immigration liaison offices, airport liaison offices, the consequences of bilateral or multilateral readmission agreements. You will find a number of remarks and also suggestions and recommendations in this report on these subjects. But to my mind, we came to, let's say, interchange of views between different stakeholders. I would like also to remind all of us that we have now EASO, we have the European Asylum Support Office. They are active, they are in the position now, I think, to give the support, in particular in stressed situations of particular member states. I have the honor to be on the advisory board of EASO. We will have a meeting in December here, and I think it is also for civil society organizations. It is an ally, yeah, it is, and of course, a commissioned agency. It is a governmental agency. It is not an intergovernmental institution, but it is an important ally because, different from other agencies, certainly the objective to support and to strengthen the application of the common European asylum system. Of course, what we are discussing here, and these are my conclusive words, what is still missing, and EASO cannot, to my mind, much about it, because there is no legislative basis, is all what is linked to the question, how does a person who may need of international protection arrive at the European borders? This question remains unanswered. We had a number of elements, suggestions, enlarged family concept, family unification, sponsorship models, protected entry procedures, use of humanitarian visas, guidelines eventually. I was encouraged to hear about the growth of having common guidelines for all all the member states on the application of Article 25 of the Schengen Visa Code, that the article which foresees the possibility to issue on a national basis humanitarian visas, which is hardly never done. We have now the huge challenge of the Syrian crisis. We are interested to know what is the outcome of the Berlin conference today. If there's some move towards really greater acceptance of Syrian refugees in the European Union. I thank you very much for your participation, for your patience, and have a good way home.
In 40 Minuten bin ich im Flughafen.
Ja.
Wenn Sie mich anrufen können,
Ja, mach ich gerne.
0039
0039
335
335
6248
6248
775.
77. Alles klar.
Ja,
ich melde mich
okay,
gleich.
das
Vielen
ist
Dank.
dann
Ja,
ein
ist
bisschen
einfach
ruhiger.
in Ruhe, ja. On the international organizations.